Attention students, I know this is that time of the year when we are about to part ways. You have to go and face the reality in the world out there as professionals. Well, I am not surprised that you've got the same feeling that Solomon Mahlangu had when he was about to be marched to the gallows. It is the same feeling. Yeah, you are like people who are about to be marched to the gallows. But you should not despair. You won't know everything in one day. You will learn step by step. But it's normal for anybody to be nervous. I'm expecting that. But relax. You've got mentors, and you should use the mentors that you have, because we have made sure that the whole class is being mentored by the very same people that we went to UKZN for mentorship program. So you are part of that mentorship program, so you should not be afraid of facing the legal profession next year. You will be in the mix. You will be required to go to court, because the moment you have articles, you will then automatically have the right of appearance. But Ms. Mfusi is coming on the 23rd to talk to you about that, so I don't have to go there. She will be coming to talk to you. But anyway, we have had classes, but I see that our classes are disrupted by the virtue of there's no water on campus, and just now on Friday we'll have recess and you will be gone, and we only meet on Fridays. So I have decided that I should try and learn to do these videos so that in your spare time you can have a look and remind yourself. If you've got anything, you can post in the group or anyhow, but it's good if you post in the group so that everybody can benefit. Then we can use that medium to sort out your doubts and where you do not understand. We've spoken about summons, right? I've told you summons. I told you there's something called long form and short form. The long form, that's where you will be warning your opponent to file the notice of defense with so many days, 10 days and 20 days for the plea. That is a long form. You give them a chance to respond, which is that is called audi alteram partem. You give the other side a chance to say his or her side of the story. So that's a long form. Short form will be summons. We've got summons with prior notice and summons without prior notice. So it's the long form and the short form. The short form, I told you, the best example of a short form is when you will be applying to be admitted as an attorney or an advocate. That's an ex parte application. Right? You can also do an ex parte application, if I'm not mistaken, when you're doing what is called the ad litem. Is when you're applying for someone to administer his affairs. Somebody who is extravagant or who has been mentally disturbed. So you will make that application to court and be granted that you will be administering his affairs because he is mentally disturbed of whatever reason. But we'll get to that. That's where it's called. You are going to be the curator, right? Oh yes, curator ad litem. Okay, fine. Now let us now come to the two things that I want us to discuss. The first one is we'll make these videos 10 minutes strictly 10 minutes, and then we cut so that it doesn't become boring. Now we are on 5 minutes. So there's two things. There is an application and there is action. So I want us to differentiate between action and application. Action will be where you issue summons for damages, or where you issue summons for divorce. That will be action, right? And applications are only brought to court by way of a notice of motion, right? And application, the difference is that in application we've got an applicant and we've got a respondent, whereas in the action we have a plaintiff and a defendant, right? So you may, in applications, even in action as well, you might have first defendant, second defendant, third defendant. Same thing applies with application as well. You must have first applicant, second applicant, third applicant, especially when, like for instance, the example I gave you in class where the children of the deceased were contesting their stepmother to say she's not supposed to be the executrix. Be careful, executrix. A female cannot be an executor. A female will be an executrix, and a male will be an executor. So they were making an application for the lady to change her status of being an executrix, and it was decided that a neutral person must be the executor of that estate. That was the decision of the court at the end of the day. So, like I'm saying, in that application, there were about 10 or 15 applicants. So there were about 10 or 15 applicants, and my point that there could be more than one, even on the action as well. There could be more than one defendants, right? Now, especially when you are dealing with, let's say, we are dealing with where you are about to repossess a house when the husband has died. So it's going to be the estate of Mr. Mzobe and Mrs. Mzobe. So you've got two defendants in that case, right? So that's how it comes about. It could be 2 or 3, right? Now, let us now come to drafting of pleadings. Right? When you're drafting of pleadings, I cannot teach you the skill of drafting pleadings, but as you go on with your legal profession, you will find that each and every day you are getting better and better in drafting, in the way you express yourself in your summons or application, because I may give you precedents which are just a guideline as to what that particular seat of the court requires you as an attorney or advocate to draft your pleadings. So you will, like they say, practice makes perfect. So as long as you keep on practicing, you will then ultimately become perfect, right? Now, we all know that our law in South Africa is based on the principle of exchanging of written document. That is now the law governing the system of civil procedure. When we talk of civil procedure, then you must know that there is going to be documents exchanged between yourself as the plaintiff, if you have started the matter, or the other party as the defendant, or you as the applicant against the respondent, right? This is in compliance with the principle of audi et alteram partem. Right? It's a technique that is used when we are litigating, because you have to notify the other party. Right? You have to notify them of your intentions and what is contained in those summons or application, right? So this was emphasized in a case of King versus King. The citation of that case is 1971, volume 2, SA 630, right? 630. You will find it on page 630 of that case. It's a 1971 case, so it's a volume 2, right? In that case, it was emphasized that the importance of pleadings is to inform the parties what the issues are, so that they can be able to prepare for trial. So as a plaintiff, you are obliged to inform the other party about the issues in the case, as to say, is it a breach of contract, is it a motor vehicle collision, or is it defamation of character? It could be anything. So you need to state in your summons as to what the issues are, right? And another important thing is to inform the court of the issues in order for the court to know the extent or the scope of the dispute. That is why you are obliged to have 3 copies. 1 copy will be in the master file in court, right, with the registrar or with the clerk of court, and the other file and the other copy will be one sent to the defendant or respondent. And obviously, as an attorney for your client, you will have to keep 1 copy. But in some cases, you might have more than 3 copies, because sometimes you'll find that the particular case will be in front of 3 judges. So you need to provide a copy for each judge, and sometimes the respondents, you've got more than 1 respondent, so each respondent should have a copy, or each defendant should have a copy to the case. So you will have to make copies, to make as many copies as possible. That will make sure that everyone who is involved in that case has a copy, right? Also, it is important to place the issues on record in case you must place the issues on record, right? That is, now when you've got everything written, that means all the issues, right, are on record, so that if anybody wants to reopen the case later on, then you know that there is a record. It's recorded in the papers, and it's also recorded in court. That is now recorded in court. You can get transcripts if you like. If say you want to appeal, then you can get transcripts from that record in court, right? It is also important that the issues are set out in the pleadings precisely and with sufficient explanation or particularity, if you like, so that The issues are there. There is nothing hidden. Everything has been said. Every litigant knows exactly what he is facing, and you know exactly what your issues are, because you have consulted extensively, so that you will know exactly the whole extent of the case, right? Preciseness should, however, not be equated with furnishing of unnecessary details. So you don't have to state everything. All that is important are the facts that are relevant to the particular matter before the court. So you don't have to state, what we call side issues. You only talk about what actually happened, what led to that particular dispute, if it's a dispute, right? Right. Okay. What is important when you are drafting? You need to use simple English. Do not use bombastic words. Try by all means to use simple English so that everybody can understand. Right. Let's just stop there for a while, and then we'll continue.